This is You and the Law on AM 650. Now back to the show.
Sterling Fox with you on this edition of You and the Law, joined in studio by David Hobbs from Hobbs Giroday in Vancouver. And our subject today is power of attorney. Something, David, we hear this phrase umpteen times throughout our lifetimes, and we all have power of attorney. It's on TV a lot, even on those U.S. law shows that we watch too many of. So we all think we know what's going on. And then all of a sudden when push comes to shove, well, maybe not so sure after all. So thank you for your patience in walking us through all of this. Now, how does one go about granting power of attorney? Do you go online and get one of those fill out the blank forms, or go to the drugstore and buy a do-it-yourself kit, or see a lawyer? What's the usual process that people go through to grant a power of attorney once they come to the decision they need one in the first place?
Well, I think what I see, most often people will go to a notary or a lawyer.
Okay.
And have that person prepare the power of attorney and attend to the execution of it, witness it, and so on. And, there's a good reason for that, and that is that when you're talking about powers of attorney, there is a finer discussion of it, and I would break it down this way. I would say that firstly there's general powers of attorney, and the word general means the power is general, i.e. it's every power that the person who granted the appointment has. It's as if the attorney it can make all the decisions that person could make.
They become you.
They become you.
Right.
And with regard to financial matters, you can have a specific power of attorney which only gives a specified power. It isn't general. It's a power to do a certain thing or a series of things. You can have a general power of attorney that is general, but it has exceptions. So it's general, but you can't do this and you can't do that. And so what you want to accomplish may impact what that power of attorney should say, the drafting of it and so on.
Already this is sounding much more complicated than something that you could do online.
Yeah, I know that people are concerned about cost and so on, and trying to be efficient and trying to be a do-it-yourselfer and so on. But I would say that this is an area where, penny wise, pound foolish. It's not that expensive to have a power of attorney created in any event. And then the details of them becomes a little more insidious, because if you're dealing with land, then a power of attorney that's more than 3 years old will not be accepted by the Land Title Office unless it specifies that it exempts the section of the Land Title Act, which is Section 56.
So you're talking real estate transactions of any kind?
So if you think you're granting a power of attorney that someone could help you with real estate transactions, if it becomes more than 3 years old, it won't be effective for real estate transactions. And then the other, I think, important concept is what we call the enduring power of attorney. And those words that make it enduring have to also be drafted in the document. And basically, in simple terms, what the document says is, if I become incapacitated, incompetent, this attorney can still be my attorney. They can still make decisions for me, even though I'm not capable of even knowing what they're doing anymore. And so the word enduring reflects that it endures my loss of capacity. It continues.
So you have to specify, though. I'm trying to keep up to you here. If you are thinking about power of attorney, for example, because you are feeling a little poorly, and people are expressing their concerns about your well-being, then you've really got to pay attention to the details. It's all about the details, isn't it? And a general power of attorney, perhaps if you're particularly feeling a little delicate on the capacity side, would not be the route to go then, because you want to be confident that should you begin to lose your capacity to look after your affairs, then a trusted person can step in and do the job for you regardless of how incapacitated you become.
Right. And then when I use the term incompetent or incapacitated, I mean I'm really talking about a gray line that has to become a black line. You have to become incapacitated. So if you're not, you're not. If you are, you are. But once you become incapacitated, then if it's an enduring power of attorney that you originally created,
you're fine.
Then you're fine, and the person will be able to carry on helping with your financial transactions. But if you don't draft it that way, they won't.
Can you revoke a power of attorney? Suppose you grant somebody a power of attorney, feeling that this is someone you've known and trusted your whole life, and a couple of years down the road, the person turns out to be, well, lesser human being than you anticipated, and you think, I don't want this person in my life anymore, but I've given him or her my power of attorney. Can I revoke it?
Definitely, and it's the revocation would be in writing, and you would inform the person, and you would make all efforts to retrieve. If the original document was out somewhere, you would retrieve it, and you'd retrieve any copies of it. You wouldn't want the person wandering around pretending that they had something that had been revoked. But if you can prove that you've revoked it and made all efforts to communicate that and inform the attorney that they're no longer your attorney, then they're not going to be able to create transactions that bind you.
So if the devil is indeed in the details, David, all the more reason to have these documents of powers of attorney, regardless of which category you go after, drawn up by a detailed professional, as in a notary or a lawyer.
Yeah, and it's self-serving for me to say yes to that, but the reality is they're not that expensive, and it's a penny-wise, pound-foolish decision, because it's a very, very important document, and relative to cost, you should make sure you get it right, and it does for you what you want it to do.
And the reason I ask you this, I'm kind of setting you up here, because when it doesn't happen properly, then you get into disputes, and then Hobbs Giroday goes to bat for somebody involved in the dispute, and off we go. In many cases, do you act for clients who are feeling wronged in the resolution of an estate or a will because someone had the power of attorney and didn't perform the way the rest of the people who are named in the will expected him or her to?
Yeah, we have lots of people who come in and we discuss what they believe has happened or what they know has happened, and then you get into a discussion really about, and what it really boils down to is if you see something has happened regarding someone's estate or their financial affairs, the question is did they intend for that to happen? Is that what they wanted to happen? And or has someone used a power of attorney in a way that was never intended and is really not for the benefit of the person who granted the power of attorney and is for an improper purpose?
Well, now you see, you stand in a supermarket lineup and you're going to see somebody's magazine cover where an 85-year-old guy married a 23-year-old girl, and there's adult children and grandchildren and all sorts of. Nobody's happy, and there's going to be one of those Hobbs Giroday moments at the end of all of this, because there's going to be a massive court case, and in many cases the pitch is made to the court that someone has manipulated this older gentleman in this particular instance to the extent that the power of attorney was granted or revoked perhaps from an adult child and given to the new trophy wife. All the estate is now in her name, etc., etc. It's more common than many of us would believe, isn't it?
It is. I hate to use the word common because you hope there's some, we'll call it ordinary situations out there where people don't suffer these problems. But what we see, for example, is elderly people. They maybe lose their spouse of 40 or 50 or 60 years of marriage.
Yeah.
You can imagine the impact on a person, suffering that, and then a new person comes into their life immediately, unexpectedly. Cookies and milk. It could be just the most unusual thing. I remember one matter we were involved in. The young lady was dating a gentleman who happened to live on the same floor as the old gentleman in the apartment, and so they would bring cookies and milk over to this gentleman. Well, the boyfriend-girlfriend broke up, but she continued bringing cookies and milk. But and shortly thereafter, there were powers of attorney, and there were wills made, and there were all sorts of things being created. And
interesting.
And it, on the face of it, it just doesn't look right. And that's the beginning of the inquiry, and a lot of times you have to look at the detail of these things.
Well, and I guess there's a certain measure. Now, where does the court come into this, David? Because you go to court a lot. Because a person who is vulnerable, say, particularly after having lost a spouse in their advanced years, suddenly, taken advantage of, one might say. Certainly their adult children are insisting they have been.
Right.
What does the court have any duty to that frail, vulnerable old person, or is, hey, that's life, buddy, tough break?
Well, in the context of powers of attorney, we have legislation in British Columbia which is called, amazingly enough, the Power of Attorney Act.
All right.
And it has a section in it that recognizes the court's parens patriae jurisdiction. It's a Latin phrase which really refers to the court's inherent jurisdiction to protect people that are vulnerable.
All right.
And so if someone had a power of attorney, for example, and they were transferring assets to themselves or friends or abusing it in some way, the court has a power to address that situation based on that long-standing inherent jurisdiction to protect vulnerable people.
Have there been circumstances where a person has abused a power of attorney and spent more than was expected? This wasn't part of the deal. I wanted you to manage my affairs, not spend my wealth. Does the court ever get to the point where the person who has dispensed with money beyond their mandate to return the funds?
Oh, definitely. Yeah, we sometimes obtain injunctions, which are interim measures until the final decisions are made about the matter, freezing assets, and maintaining the status quo. And then that allows a review of what's happened and to determine what the facts are and so on, ultimately leading to a final decision, which might be an order that someone pay something back or return a piece of property. We put charges on land, certificates of pending litigation, and other things. They're all devices to freeze and protect and preserve the status quo while there's an investigation or a court proceeding involving a dispute.
David, I've never had this happen to me, but if someone ever approach me and say, Sterling, I'd like you to grant you my power of attorney. I trust you implicitly. We've known each other for decades. And, if things go south on me, I want to have somebody like you around to take care of biz for me.
Mm-hmm.
How do I respond? And what should I understand at that moment to be my duties? Should I say, sure, no problem?
Well, I think the most important thing to understand about a power of attorney is it's for the benefit of the person who granted it to you. I.e., the decisions you're making are for their care, their benefit, their health, their financial well-being. And so if you have to understand that you're looking after them with this device that they gave you, this power, that you're not looking after yourself, you're not looking after somebody else. You're there. Yes, you can make financial decisions, but you have to justify that decision for their well-being. And I think that's a concept.
And it's not a money-making proposition for me either, is it?
No, and one of the difficult areas you commonly get into is when the person who granted the power of attorney gets very ill, maybe they're on death's door. The attorney all of a sudden thinks, well, I better use this thing quickly before they die and transfer everything to whomever. As some kind of estate planning exercise, because they know that when the person passes away, the power of attorney is gone, and things will be dealt with under a will, and that's a use of a power of attorney that's improper because it's not for the benefit of the person who granted it. All you're doing is some kind of accelerated asset transfer exercise on death's door. And that's not what the power of attorney is designed for. It's not its purpose.
Well, it's interesting because as we learn about this, and we learn about this whole concept of power of attorney, I didn't know, for example, that we have a Power of Attorney Act, so that all of this business between humans is controlled in law by very strict parameters. There are borders around powers of attorney that you can't cross over without getting into trouble.
The issue, there's two issues that come to mind. One is, firstly, the person who makes the power of attorney, who grants the power of attorney, they have to have capacity to grant that power. Same as a person who makes a will, a person who makes a contract, a person who gets married, a person. There's always in law what we call capacity tests, and they're not the same for each type of activity.
Okay, sure.
But the capacity you have to make a power of attorney is similar to the capacity that you have to make a will. You have to know what your property is. You have to know what it's worth. You have to know who your close relatives and friends are. You have to know what the power of attorney does, i.e. empowers the other person.
Right.
You have to know that they might make mistakes and devalue your assets using these. So you have to have all these understandings to meet the test for capacity. Otherwise, if you didn't have capacity, the power of attorney would be invalid. It wouldn't be a valid grant. So that's one concept. Is it a valid power of attorney?
Fair enough, yeah.
The other is the duty of the attorney, and the duty of the attorney is to act in the best interests of the person who granted the power of attorney. Be their agent,
right.
but to act in their best interest, and to not do things such as, for example, spend their money in a way that they now can't look after themselves with their money because the money's been spent on investments or something, and they
right.
really need the money to pay for their medical care or where they reside in an elderly facility or something like that.
Right.
It really, your decision making has to be that of what the law calls a prudent business person.
Right.
You make common sense, prudent decisions. You can get advice and so on. That's fine.
But it's interesting because you use the word agent, and typically in showbiz and sports, agents make about 15-20% right off the top of whatever their client makes. This is not that kind of agent at all, friends. Power of attorney has nothing to do with what percentage is in it for you. It's a service you provide as a trusted friend or family member.
And it's not typical, it's not impossible, but it's not typical that the attorney would be paid anything.
Right,
It's
exactly.
not a compensation exercise.
Right.
It's a help someone who trusts you with an issue exercise. And the other thing about your duties, in addition to being honest and acting in good faith and all those things, is that you have to only act within the scope of the power you've been granted, which is the wording of the power of attorney. If it's general, well, it's very broad, but it may not be. And you must keep proper records of everything that you do, because the attorney, the person who grants the power of attorney, if they pass away and they have an executor, the executor may come to you and say, I'd like all the paper regarding your
what have you done?
Your transactions.
Exactly,
and you
sure.
have a duty to produce all of that accounting.
Interesting stuff. Our guest on this edition of You and the Law here on AM 650 is David Hobbs from Hobbs Giroday in Vancouver. We're talking power of attorney, and there's lots more ahead. Stay with us.
There's more of the show still ahead. This is You and the Law on AM 650.